afternoon. Brandy Jones for the appellant, Johnny Kummer. If I could reserve 3 minutes, please.
3 minutes, okay.
This case is fairly simple, especially compared to, I think, what we just heard. This is a divorce case for which the trial court granted a motion for default, entered a final decree and an amended final decree based on that default judgment against my client, and the court also did not set aside or alter or amend the final decree as requested timely in the trial court. And so our issues before the court today are whether the trial court erred in failing to set aside or alter or amend the decree, and also attorney's fees. Most of the facts in this case also are not really in dispute. The wife filed her complaint on March the 4th of 2022. It is not disputed at that time that the parties had been separated for about 7 years, but they had been married since 1985. This was a long-term marriage. It is also not disputed that the husband was in Hardeman County Correctional Facility at that time. He was released from that correctional facility on March the 16th of 2022, also not disputed. He was transferred from there to a halfway house in Jackson, Tennessee, where he still is today. The summons on this case purports that the husband was personally served on March 15th, although even the trial court said that the summons is impossible to read. It could say March 15th, it could say March 16th. It's also not possible to read the sheriff deputy's signature. Even the trial court found that it is entirely possible that the husband was not personally served because of the procedure.
Where did the trial court find that? I'm looking at the statement of evidence, and
It is the record volume 2, the statement of evidence at 4. The court found the information on the summons was impossible to read, and the court did not necessarily dispute the process of service in the jail.
okay, so how do you glean from that it was possible he was not served?
Based on that, because the summons was impossible to read if he had been served on the 15th or 16th, and because it's not disputed he left the facility.
I mean, to me, it seems like we're stuck with the factual finding that your client had no recollection of being served, and that's really all the trial court has said in terms of a factual finding.
Correct.
And also, the court made a determination that he found your client's testimony neither helped or hurt his motion to set aside. So, I mean, without more, don't we have to rely on that summons that there was personal service?
And I think that's probably what the trial court turned on, even though that may not really even be clear in the record. But the court's finding that my client did not give testimony that could favor setting aside the default judgment, my argument is that that's an erroneous application of 60.02. The trial court clearly found that my client was somewhat confused, possibly somewhat incapacitated.
Okay, well, let me ask you about that then. Are you suggesting then that the service should have been made in a different manner rather than 4.041, it should have been under 4.042?
Well,
and if so, where's the proof of that?
my client did have a power of attorney.
But that didn't mean he was incompetent.
Correct, and I don't think our argument is that he was incompetent, but it's that he had severe mental and physical health implications that would make it difficult for him to handle this process. The court took testimony as well, which is undisputed, that there was a previous divorce that had been filed that was later dismissed, and my client had his power of attorney handle that divorce.
But if that, I mean, but that argument wasn't made below. It seems like to me that if there was a incompetence allegations or claim made here that this service wasn't effective because of that, the motion should have said personal service would not have worked here. It's 4.042, and you had to go under that. It had to be served on the guardian or a parent, and that argument wasn't made below.
Because it was a power of attorney. There wasn't a conservatorship.
Right.
There wasn't, a conservator or a guardian.
So I guess that takes us back to, it should have been under 4.041, and the question about personal service. And so what proof was offered beyond your client's testimony about there actually wasn't personal service here?
Other than the court's finding that the summons could not be read or was illegible, the proof was primarily from my client, who did say he did not recall being served with anything. That is correct. But again, I think the trial court made other findings that would lead to this either being set aside or, again, altered or amended. I requested 2 forms of relief. There was actually no findings or even a ruling on the alter or amend. It was just basically a denial to set it aside because my client did provide testimony about the assets that were in this long-term divorce, significant assets of a marital residence, my client's own truck. He was awarded nothing, and very clearly that is an injustice.
And so in terms of relief that you're requesting here, your relief is not that you would the whole thing should be set aside. You don't want the parties no longer to be declared divorced, or is that part of what you're asking for?
No, Your Honor, the parties should be divorced, and I think both of them want to be divorced.
Because it's really difficult to unscramble that egg after a period of time.
It is, and so again, that was really the alternative relief sought in the trial court was to alter or amend, because obviously, as we know, defaults are very one-sided, but this was very one-sided. My client very, very severely is prejudiced under the amended decree as it is. Again, a 30-year marriage, significant asset in terms of a house, retirement accounts, and just personal property. My client didn't even get his own truck. So it really is more, I think, of an alter or amend situation.
What about the wife filed the motion for default judgment on May 20th and mailed it to the Hardeman County Correctional Facility? Did he ever get that? Is that part of this too?
Correct, and it is not disputed that wife's counsel at that time filed multiple, of course, motions and orders, and all of those went to Hardeman County Correctional Facility. There was no dispute of that in the trial court and no dispute of that as of today. Even the trial court found that the husband did not and would not have received any further filings in this matter.
Counsel, is there any finding in this case that he was personally served on the 15th? And it seems like there's potentially ambiguity in the statement of evidence. Is there any finding here that says the 15th is the date of service?
There is not. There is just the trial court's finding that the summons is impossible to read. It really, I mean, of course it's in the record. You can't really tell if it's a 5 or a 6, but that is really the only finding, is the trial court said it's impossible to read.
In terms of the divorce and awareness of the divorce in this case, the testimony from husband was that in referring to a divorce, there's uncertainty as to whether he's referring to the first divorce proceeding or this divorce proceeding. Is that correct? That's
correct. He testified that he became aware of a divorce at some point. He testified that his aunt, who was his power of attorney, had contacted him both times to let him know of a divorce. But there was a divorce in 2018. My client's power of attorney hired local counsel to represent him in that divorce. That divorce was ultimately dismissed for the wife's failure to prosecute, and my client was in the Hardeman County Correctional Facility at the time that divorce had been filed. So He clearly was served with that divorce, hired counsel, and it just ultimately was dismissed. So in his testimony, he never could really clearly differentiate which divorce he was discussing.
And we don't have a transcript, we have a statement of evidence here. Is there any indication that he was aware of that prior to, that when he's talking about awareness of divorce, that it's relating to prior to the family notification as to divorce?
His testimony, albeit even based on the trial court's findings, I think was just kind of jumbled and unclear because of his disabilities. He could never clearly articulate which divorce he was talking about or when his awareness, but he did say he did not recall ever being served with anything and was very shocked, very upset when he found out that this default had been entered and he lost everything. So it's just, it's not clear, unfortunately, but I think based on even his own emotional reaction, which the trial court noted during that testimony, he was very emotional at having not known about a divorce and that he had lost everything. So ultimately, the trial court upheld the default judgment, and that's why we're here today. I think the trial court also failed to look at the husband's conduct, whether or not it was willful, which is what is required by case law. Clearly, he didn't exhibit any willful conduct here. Again, the dispute comes to, was he ever even served? If he was personally served, he was immediately transferred to a halfway house. He had no receipt of any further pleadings. To me, all of those things show that he wasn't willful. And additionally, as soon as the family found out that this had been entered, they hired counsel timely and filed a motion to set aside timely, all of which would point to the fact that he didn't have proper notice and he acted very promptly to try to remedy the situation. And just briefly on attorney's fees, again, he's in a halfway house, very limited income. The wife has all the assets, so we would ask for the court to remand and let the trial court consider the amount of attorney's fees.
Okay, but under what grounds, there wasn't any statute or anything cited for the basis for an award of attorney's fees?
For the fees, the case Moran versus Walensky, just looking at the party's ability and whether the appeal was taken in good faith and equitable factors.
So you're saying it should be awarded like alimony in this case?
Correct.
Okay.
Thank you.
Good afternoon, Your Honor. Wendy Rutherford of the Nashville Bar on behalf of Mrs. Kummer. Ms. Kummer. Basically, this is a situation where the court ruled in its discretion to uphold the default. And this court is required to begin the presumption that the decision is correct. It's an abuse of discretion standard and should review the evidence in the light most favorable to that decision. While the summons is, it's not clear as to the date or the signature of the sheriff's deputy that served it, it's very clear that it says personal service. If there was a need to take evidence as to whether or not that actually happened, Hardeman County probably, I don't know, but I would guess in my experience, would have a record of the name of the sheriff's deputy that served that. And that could have been proof. That could have been, but it wasn't.
Well, I mean, ordinarily, a return of service on a summons is given presumptive weight.
Correct.
Right? And I guess that's what you are riding on here, is you got that presumption, and the presumption can't be rebutted by an interested party. But, you know, if there's some defect, for example, a signature that cannot be raised, do you still get the benefit of the presumption?
I would say so, Your Honor. The service of process was by the Hardeman County Sheriff's Department.
Yeah, but I mean, well,
If they can't read the name of the sheriff,
Yeah,
and
so-
some people's handwriting is illegible.
are you suggesting, though, that there's, you know, suppose the summons just hypothetically came back with Donald Duck as the serving party.
I would want to know who Donald
You,
Duck was.
you would still give that presumption?
I would.
Okay,
There may
okay.
be someone named Donald Duck, and Hardeman County would know that. The sheriff's department would know that. If you can call them up and say, you have a deputy by the name of Donald Duck, and find out whether or not that's, accurate. What we do know, regardless of whatever date it was served on him, it was filed with the clerk on March the 24th. And my client did not file a motion for default judgment until May, well 30 days after the return was filed with the clerk. So regardless of what the date is on there, whether it's the 15th, the 16th, the 14th, she filed the motion for default judgment more than 30 days after the summons was returned from the Hardeman County Sheriff to the Davidson County Circuit Court Clerk's office.
Counsel, is there anything in the findings of the trial court in this case that says this was served on the 15th? And do we have any finding to that effect from the trial
There
court?
is not a finding specific as to the date of service. And there is a finding that the court couldn't read it and nobody else could. But I would submit that it's incumbent on someone that the burden of proof that this service was not valid would be on the person trying to dispute it. And the evidence is easily ascertainable through the Hardeman County Sheriff's Department as to the date and the person who actually served it. It's not, my client has, I believe, the right to rely on, she paid for the service through the Hardeman County, and to rely on the summons that was returned to the clerk's office. And to rebut that would be, the burden should be on the person trying to get out from underneath that. Now, whether or not it was served, the summons says it was personally served on the defendant. And I think that absent proof otherwise, wherever he was, whether it was served personally on him.
The statement of evidence includes indications as to the procedure of how things are working in Hardeman County, and notes that they sign off on the summons as personally served when it's not personally served at that time. And isn't that some evidence that it wasn't actually served upon him at that time?
I would submit that that wasn't evidence, Your Honor. Those were statements of counsel as to her experience with Hardeman County, and I don't believe that that's evidence that the court could consider. Statements of attorneys are not generally evidence. The evidence would have been someone from the Hardeman County Correctional Facility to provide an affidavit or to testify that that's how that is. But for counsel to say that I think this is the way that it happens is not evidence, at least not evidence that the court should rely on in making a decision about setting this aside. It's a possibility that that happens that way. It's also a possibility that it doesn't, or it happened that way one time and it doesn't happen that way. It didn't happen the way the other. The only evidence as to service of process is the summons itself, which says it was personally served on the defendant. And if that's not, if the burden of proof as to the reliability of whether that actually happened would be on the person trying to contest it. With regard to the fact that he moved and did not receive any additional notification, the case law is pretty clear that if a litigant proceeding pro se relocates during the course of litigation, he's encumbered with the responsibility of notifying the court of his new address. That didn't happen, and there was no evidence that he contacted the plaintiff or the plaintiff's attorney and provided a new address. After service of process is made, after a defendant is personally served, it's not incumbent on the plaintiff to continue to try to look for him to make sure that he gets notifications. It's his responsibility to notify people of where he can receive that. And so I think that the issues here are really clear. You had personal service, whether he remembered being served, that he didn't deny being served, he just didn't remember it. He didn't say, I definitely never got this. He said, I don't remember it. He's not incompetent. He may have issues. We have people with issues coming before the court all the time. I mean, where do you draw the line in making accommodations for people? I mean, we have, you know, processes where people can obtain conservators and do things if they're not competent to handle their own affairs. And they can do that voluntarily or involuntarily. But he was personally served. He did not notify anyone of the change of address. There was nothing that counsel could do but continue to send notifications to the address where he had been personally served. The date on the summons, while it's not necessarily legible, was filed with the court on March the 24th. So we know that he was served before March the 24th. A motion for default judgment was not filed until May the 20th, almost 60 days after the service was filed with the clerk. The question is, what is the plaintiff's responsibility in this situation? She did what she was supposed to do. She filed her complaint. She had process issued. She sent it to the sheriff of Hardeman County, who returned service saying that the defendant was personally served. Her counsel sent notification of further proceedings to that address. Now, Mr. Kummer didn't notify anyone of his change of circumstances. There's no proof he notified his wife of his change of circumstances. There's no proof that he notified anyone that he left the Hardeman County Correctional Facility.
Counsel, at the hearing on the Rule 60 motion, was the return of service actually offered in evidence? How did the court
I was
start
not present, Your Honor. I don't know the specifics of how that happened. I do know Judge Robinson very well, and it's possible that it was, and it's possible he also took judicial notice simply pulling it up on his computer in front of him.
Okay.
But I don't know the answer to that question because I was not the trial counsel. And there is not a reference in the statement of evidence that what was received into evidence with regard to that either that I'm aware of.
Counsel, is there a factual finding anywhere here that he actually was served? The trial court may, and not just the 15th, but that he was served in this case.
I will confess that I don't recall that specifically. I don't know. And I don't have the statement of evidence sitting here in front of me to answer that question. But I would submit that the only evidence of service in this case is the summons, which very clearly, and I can read it, and I would submit that everyone else in this case can read it, says that he was personally served. And I don't believe that Mr. Kummer denies that he was personally served. He simply says he doesn't remember whether or not he was personally served. The issue here appears to be it's not valid because I can't read the date and I can't read the deputy's signature. And you can't. I can't. Maybe somebody else could. Maybe it's because it's a copy. Maybe the original was more legible. I don't know. But I think that the affidavit of the sheriff saying that he personally served him, and if there was a question as to whether this was actually a sheriff or what the date was on there, if it was actually personal service, then again, that burden falls to the defendant to bring in the evidence from the Hardeman County Sheriff's Department or from the Hardeman County Correctional Facility that this was not valid service. And I think that we have the right to rely on what was filed with the trial court, that he was personally served. And again, with regard to, the timeliness of it, whether it was the 15th or the 16th, it was not, the motion for default judgment was well over 30 days, over 60 days, either of those 2 dates. We do know it was filed with the clerk on March the 24th by the Hardeman County Sheriff's Department. And at some point in time, we have to be able to rely on what the sheriffs are doing when they're serving process, and when they're out there doing this, we need to be relied that they're telling the truth, that this is what's going on, and be able to, if that's not the case, then the burden of proof is on the person contesting it to say otherwise. That would be my argument, Your Honor, other than with regard to attorney's fees. Again, this is the standard of review is abuse of discretion. You know, you're obligated to look at the evidence most favorable to the decision made by the trial court. And as such, I would submit that it needs to be affirmed. The issue of attorney's fees becomes moot. But otherwise, you know, if the court were to do something different, there is no evidence in the record with regard to ability to pay or need. I don't know what his assets are, and neither does anyone else. But that is the standard with regard to the award of attorney's fees, and I cited the Kane Swope case in my brief as with regard to that. Thank you.
Thank you. Ms. Jones?
Thank you. The trial court did look at the summons. I don't recall if it was offered or if maybe the clerk did print it off the computer sitting there next to the judge, but he did see the summons. There was no finding that my client was served or not. It was just the court said maybe he wasn't served, but I think
Well, but isn't that the natural inference from the denial of the motion? I mean, I don't know how you could read the denial as anything other than the court finding, well, I mean, because that's the upshot of the motion to set aside, right?
Sure, I think that's the implication. I just,
Yeah, so, I mean, I don't want to, you know, it's one thing to say courts need to make specific findings of fact, but when you can imply them from the ruling, I mean, it's hard for me. So, I mean, I guess I'm back to 4.01, which tells us that the return endorsed on a summons shall be proof of the time and manner of service. And I appreciate counsel made all these arguments about, well, this is the way it works in Hardeman County, but this return says personal, and so don't we have to accept that under the rule?
that is what it says. I do not think it should say that because it's not just Hardeman County, but for all facilities, that is how service is obtained. It's not served on
The inmate personally.
because the inmates are in cells off. They just take it to the front of the office. And I think the date is important because it is undisputed that Mr. Kummer was transferred from that facility on the 16th. He was no longer there. And yes, of course, a defendant has the responsibility to notify a trial court if they move, but if he didn't get served, he would have no idea to
Well,
provide
but as I understand the factual dispute here, it's, well, it either says the 15th or the 16th. So even if we read it in the best possible light for your client and say, well, it was the 16th and that's the day he was released, that doesn't necessarily mean he wasn't served on the way out the door. So I know it's unlikely, but
Right.
you know, that's still within the range of possibility. And then we're back to the rule says shall be proof. I mean,
But I just think we're also looking at all the other factors. The fact that he was previously served in prison and hired an attorney through his POA, and his aunt, who was the POA, did do an affidavit that is in the record about how she found out by a phone call from my client's former attorney who saw this on the docket, and that's how she became aware of this default. So my time is up. Thank you. If there are no further questions.
Thank you both. Would you please recess court until tomorrow?